everyone, Mark here. It is the 9th of November, just after 10 o'clock, and I am heading on my way to Manukau to go and see our wonderful friends at the Manukau District Court. Now, I was going to email Chris Hurd, but as you can see, I'm not wearing a jumper. And basically because it's coming into summertime, it's too fucking hot to wear a jumper. But as I've said on the previous video, Chris Hurd didn't exactly address the harassment and discrimination by his court security officers against me. All he did was go on about my fucking jumper and recording in court, which he himself has said it's not against the law. It's not a criminal offence. But he just does the typical old, well, we'll threaten to trespass you. Well, that's great. I'll just go and get a fucking speeding ticket in Manukau and I'll be back in court and the trespass will be void. You're going to have to keep trespassing me every time I go there if that's your issue. But, yeah, so I'm heading there now. It's not just me and Tony. There may be other people there as well that have come along to watch that aren't related to me or have anything really to do with me, but they've just come along as an independent eyewitness, which I appreciate. And believe me, those people also know the law. So it's going to be a very interesting time. I will keep you all posted. We'll see how the case management hearing is. Now, in fairness, fuck if I know what this case management hearing is all about. As far as I'm aware, the criminal offence that he's being alleged to have committed, I think it's a Category 2 offence. But the kicker being is that he entered a not guilty plea on the 5th of August. And initial, if not full disclosure, is supposed to be supplied as soon as practical after that not guilty plea has been entered. Well, it's been 3 fucking months. Do you think that he's been given any sort of disclosure at all yet? No. I mean, we've given them the raw footage of the police officers assaulting him. And as you can tell by the charging document, Cherie here, the upstart little cop that took issue with being recorded in a publicly accessible place such as an airport, has claimed that she is the occupier of Auckland Airport and therefore has the right to trespass. How does that fit with her being an independent and impartial person? Being a police officer, you're supposed to be impartial, but no. So it's going to be a very interesting day. We've got no statements from the supposed witnesses, the S25 security guard or the stupid upstart behind the counter that told Tony, that caused all of this by telling Tony to go and arrange another flight crew. Nothing like that's been supplied. So we need to see it. Now Tony's already signed an authority to act form for me to act and supply, you know, serve documents, all that sort of thing. I have authority to do that on his behalf. But I've got to get him to sign a couple more because of a couple of speeding tickets that he's also challenging now. So it's going to be very, very interesting what happens at this case management hearing. The warning that I gave the Ministry of Justice, telling them to best not discriminate or harass me or Tony any further, because we will file a civil suit against them. It's no problem for me to file a civil suit. It's not like I have a $1,700 fees to pay when I file in High Court. So I get to have a fee waiver. So it doesn't cost me a bean. So we're going to see how all of this turns out. I will keep you informed, keep you updated, and we'll take it from there. It is 1:43 in the afternoon and I'm on my way home from being at the court. Today was an interesting day, to say the least. Now, I met up with Tony, and Tony informed me that, because I asked him, have you received anything from the police? And Tony tells me that on the well, we found out what he did is he took a photograph of the initial disclosure report, the cover page that came with everything that he got. Luckily, he took a photograph of it, they received it, so he received it on the 26th of October, just a couple of weeks ago. Yeah, he's been busy at work, you know, I totally get that, and he'd not told me, so that's alright. But even though he entered a plea on the 5th of August, some 3 months earlier, and thus supposed to supply disclosure within 25 days, 30 days of it, they never do. And he only received initial disclosure on the 26th of October, some 3 months after he had entered his not guilty plea, or just before 3 months. So when his name was called, we sat there and we watched all of the paid solicitors that are there getting charging out their time. We watched all of them go through their proceedings first, and then at the last matter there was, oh, I've got a self-litigant to deal with. So I get up and go and sit at the council table, and Tony went over and stood next to the dock. Now they all looked completely confused at me, and so the judge asked who I was, and I says, oh, I'm a Mackenzie friend for Mr. Adams. She informs me that normally there's a written application to be a Mackenzie friend that gets filed. However, it doesn't have to be, and she allowed me to be there. Now, normally a Mackenzie friend is not allowed to speak. They're supposed to be a silent advisor, so to speak, to the friend they're there for. And a Mackenzie friend is basically a friend to the court, kind of like amicus curiae. So yeah, normally you're not allowed to speak. But after having a little combo with my mate Brent just a week ago, he says, well, normally that's the case, but you can actually point out to the judicial officer that you believe that you speaking for your friend will assist in the speed and efficacy of the proceedings. You know, and the judges must be all for whatever's going to make it quicker and easier. So they will allow you to speak, which is exactly what happened today. I pointed out that she addressed the counterclaim, saying that you can counterclaim on a civil suit but not on a criminal matter. So what the judge told me, and even though they've taken $200 for filing the counterclaim, no problem taking the money off you. But now the judge doesn't want to hear it because she's only new to the criminal side of things, so she tells me, and that what would normally happen is that we would go through the criminal proceedings first with the police, and then after, say, he's acquitted, then go after a civil suit. And under the relief sought in a civil suit, you can ask the court that criminal proceedings or criminal charges be laid against someone. So even though it's civil, you can get charges laid against people if you win. That could be your relief, which is only fair. So, you know, and in the counterclaim that I filed with Tony, the relief sought was that charges be brought against those police for assault. Now, under Section 48, he had the right to defend himself using whatever force he deemed necessary to do so. He was, in his mind, he was being unlawfully arrested, and ironically, in reality too, he was being unlawfully arrested. He was never told to leave. He was never trespassed from the property. For him to willfully trespass, you must first be warned. Never happened. You saw Cherie leans over to old Mr. Nicholas, I think his name is, micked in tow, and says, do you want him trespassed? And then walks over, and then they start being the bully boy and marching him out the door, frog marching him out the door. So, yeah, as far as that's concerned, the whole thing is a complete, I mean, it's an invalid charging document, for fuck's sake. Cherie here has marked herself the occupier of Auckland Airport. How does an impartial police constable end up being an occupier of anything? Got to wonder that. So, needless to say, after all was said and done, I took the judge's advice on board as far as the counterclaim is concerned. she mentioned to me that, of course, Tony doesn't have to get up on the stand and testify again, testify his right to remain silent, but Tony can call his wife, who was also there that day. And I hadn't thought of that, so thank you, Your Honour. Good of you. Thanks for the tip. So yeah, we'll be having words with the wife and stuff. The whole, as far as case management hearing is concerned, she asked if there were any other issues. I pointed out that Tony had only just received initial disclosure on the 26th of October, some 3 months after the plea had been entered, and I requested that a Section 30 order for full disclosure within 30 days be made to the police, because by now Tony should have full disclosure. Now, the police said that there were 2 witnesses and 2 police officers, so they were all up 4 witnesses, even though there's a 5th witness listed on the record, so that's going to be interesting. One of them being Fuiaba, or whatever her name was, the Jetstar obnoxious cow behind the counter, and then there's old Mick and Doe, the S25 security guy. Then there's, of course, Aaron.
2 2 3 9.
Anyway,
8, 7,
I'll be back soon. So I'll finish off where I was as far as the court's concerned, everyone. After the judge let me know about the calling Tony's wife as a witness, because that's a damn good idea, we went ahead and she made the Section 30 order against the police, and the police have to supply full disclosure within 30 days, which I'm sure they can do, because they're talking about bringing in CCTV footage as evidence, and the judge is aware that we've got our video footage as well. So yeah, that's going to be an interesting time. But basically now we're waiting 6 months after the case management hearing, which is just another time to fucking string things along. Now on the 25th of May at 9 o'clock or 10 o'clock in the morning, we've got to be back at Manukau for what's called a call-over hearing. And you might think, oh, well, that doesn't sound too bad. Well, it isn't. It just means that we've got to show up at court for absolutely no fucking reason other than them making another date, a fixture date for the actual trial, which they've assigned or allotted 4 hours. So because it's a self-litigant, they gave it longer. I've done my undertakings as a lay assistant, filled out all of that for them, supplied them all of the authority to act forms, and yeah, we'll see how we get on. I'm just going to send that through to them in the next couple of days, so they've got all of those documents, and we'll be rocking. Yeah, always, if you're going to be a Mackenzie friend or a lay assistant, always mention that you believe it would be beneficial to the speed and the efficacy of the court proceedings if you were allowed to speak for your friend that you're helping. So because the court can't say no to something that's going to make things faster and easier. So speed and efficacy is one of the principles they have to go by. So if you say you're going to be able to speed those things up, which no doubt I will be, yeah, everything will be rock and rolling. So yeah, that's where it stands. Manukau Court in 6 fucking months just to get another date to go and then have a hearing. But by that stage, I'm sure I would have done all the documents and stuff that we need. Go and have a word to the witness and see what she has to say. Yeah, and get once the full disclosure arrives, I'll to drive over to Tony's, and you know, there's no small feat. To drive to Manukau from where I live, it's an hour travel. In rush hour traffic, it's an hour and a half. So you know, it's quite a trip, and I've got to drive over and see him probably in the new year, and meet his wife and get all the documents I need, scan them all up for him, and take it from there. Right guys, so as far as all of the people that have been very generous and supporting, just you know, the regulars that I totally appreciate, and the one-offs that a few people have donated has been absolutely fantastic. And I'd like to, from the bottom of my heart, guys, thank you very much for all of your support. It does help. It makes me able to travel to where I need to get to so I can help these people. And every little bit helps. Tony's been fantastic. He's been you know, very generous as well. So, you know, but again, it's not about the money. It's about teaching people their rights and showing them how to go through the process. And yeah, the more I do it, the more streamlined I'm going to be, and the more templates I'm going to be putting in my legal templates folder. The link is in the description of every one of my videos. If you jump in there, there is a mountain of templates, case laws, all sorts of things that can help you. And you know, I'm only an email away. I've got quite half a dozen to a dozen people I'm helping out at the moment, so I do get sort of short on time, but you know, shit happens. You fight the good fight, don't you guys? Anyway, much love to you all. Peace. Catches.